This is Barry Zalma speaking for Claim School Incorporated's blog Zalma on Insurance. Today we're going to talk about why a court should never rewrite a policy, and why the insured must fulfill all policy conditions if it wishes to recover either for defense or indemnity of a liability policy. Pharmacia Corporation appealed the district court's order granting summary judgment declaring that one of its excess insurers, Twin City Fire Insurance Company, did not owe a duty to pay Pharmacia's settlement and defense costs from a shareholder class action. In Pharmacia Corporation versus Arch Specialty Twin City Fire et al., the United States Court of Appeal for the Third Circuit on January 19, 2024, applied the conditions preceding to recovery in the policy. Pharmacia, a pharmaceutical drug manufacturer, purchased a $200 million directors and officers insurance tower from 13 companies through an insurance broker. The first insurance company and layer of the tower consisted of a $25 million primary policy issued by National Union. The next 12 policies provided excess insurance totaling another $175 million. Twin Cities sold Pharmacia the 8th layer excess policy, which provided $10 million in coverage and specified that, quote, liability for any loss shall attach to Twin City only after the primary and underlying excess insurers have 1, duly admitted liability, and 2, paid the full amount of their respective liability. Pharmacia shareholders sued seeking class action qualification against the company, alleging that it artificially inflated its stock by misrepresenting the results of a clinical drug study. After 10 years of litigation, the case settled and Pharmacia incurred approximately $207 million in defense and indemnity costs. Pharmacia then provided Twin City proof that the excess carriers ahead of it in the insurance tower paid their policy limits and asked Twin City to provide coverage, and Twin City declined. Pharmacia, of course, sued Twin City. The district court granted Twin City's motion for summary judgment and dismissed the case with prejudice. The court found that 1, the plain language of the policy required the other excess insurers to admit liability as a condition preceding for coverage to attach, and 2, 6 of them had disclaimed liability, and 3, as a result, a condition for coverage was not satisfied. Pharmacia appealed. The Third Circuit concluded that no conflict existed. Specifically, courts 1, give effect to the intent of the parties as expressed in their clear language of the contract, and the plain language of the contract is the cornerstone of the interpretive inquiry. 2, may not make a different or better contract than the parties themselves saw fit to enter into. 3, courts should refrain from rewriting the agreement to accomplish their notions of abstract justice or moral obligation. And 4, courts may avoid literal construction of the words of a contract only if that interpretation defies all bounds of common sense. Analyzing the issue, the Third Circuit noted that when the intent of the parties is plain and the language is clear and unambiguous, a court must enforce the agreement as written, unless doing so would lead to an absurd result. Applying these principles, the policy unambiguously imposed 2 distinct conditions preceding for coverage to attach. Specifically, Pharmacia must show both that the insurers ahead of Twin City in the tower had 1, duly admitted liability, and 2, paid the full amount of their respective liability. Pharmacia failed to show that both conditions to trigger Twin Cities coverage were met, since 6 insurers refused to admit liability, regardless of whether the other insurers in the tower paid their policy limits. The record does not demonstrate that all of those insurers admitted liability, and the court was not required to accept the error of the 6 insurers who could have refused to admit liability if they had the same language as Twin City and still paid. Because Pharmacia failed to establish at least one condition precedent, the district court correctly declined to declare the Twin City owes Pharmacia coverage, and the trial court's decision was affirmed. In my opinion, conditions precedent in an insurance policy must be met, or the insurer has no obligation to provide defense or indemnity under the policy. Twin City established that 6 insurers in Pharmacia's tower below Twin City's obligations did not admit liability, and that therefore Pharmacia failed to prove compliance with the condition precedent. Pharmacia luckily received contributions from insurers accepting coverage, and even those who did not find that they owed coverage still paid because they decided not to litigate. After reading this case, if the 6 had the same condition as Twin City, they have explanations to make to their shareholders. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and you will be notified of every blog posting, usually 5, sometimes 6 a week, and access to the more than 4,700 blog postings. You can also subscribe for free to videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. If you're interested in more detail on insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your interest and attention.